is Kathleen Summers, and I'm with Generations Law Group. I'm an estate planning and elder law attorney, and I want to thank everybody for coming today on the first day of summer. We have gorgeous weather, and I appreciate you being here as opposed to outside and enjoying it a little bit. Today, I want to talk about taking steps to protect your primary home. We work a lot with seniors who are looking to do some advanced planning, and part of that planning may be looking to protect what really is your primary asset or your home. Carol's going to do my changing here, so I'm going to have to skip the next one. So what I really want to talk about to begin with is why even bother planning. Oftentimes people will tell me, I don't have an estate, or I just have a simple estate. I have a couple of bank accounts, my home, I only have one child maybe, or my family gets along fine. No reason to do any planning. Well, we're going to talk about your primary home today, but I also want to talk about planning and why planning is so important. Whether you think you have a large estate or not, whether you have a family that gets along really well or not. Planning for yourself is critical for many reasons. The first of which, it allows you to ensure that you stay in control for as long as possible, and oftentimes even if you no longer are able to control your own affairs. So, some basic planning documents that everybody needs to think about putting in place is your power of attorney, to make sure that you've named somebody else who can step into your shoes and make financial, for the most part, decisions for you if you can't make them for yourself. Your healthcare proxy, probably have heard about that as well. Somebody to step into your shoes to make healthcare decisions for you if you can't make them for yourself. And a last will and testament to make sure that we have instructions on what to do with assets that you own individually when you pass away. So that very basic planning is something that everybody should do without question. But primary home, that's a little bit of a different subject for people. This is your major asset. This is oftentimes at least half, if not even more, of the size of your estate for most of us. And so taking care of your primary home is very important. Estate planning or planning this way allows you to set priorities, to make sure people know what's important to you, and to make sure you have ways of communicating that to your loved ones. There are many ways to plan around the primary home, but I'm going to concentrate on 4 of them today. I'm going to talk about simply giving away your home. And what does that mean? If you decide to give it to your children, give it to loved ones while you're still alive, you want to make sure that it's going to go to them and it's not going to get caught up in the probate process when you pass away, or get attached for nursing home costs that have to be spent in case you need nursing home in the future. We'll talk about the pros and cons of just giving it away. The next one is a thing called a life estate. And a life estate is a legal term, and I'll go into an explanation as to what that means and when a life estate can be a valuable way of transferring your property. The third one is to talk about a life estate in the combination with an irrevocable trust. And I'll talk about irrevocable trusts and what they are. Think of them as steel boxes, as safes, to be able to hold assets. And the last one is a do-nothing approach, because we always have that option to do nothing. And what does it mean if you decide to do nothing and not plan at all? So let's start with the first one, giving away your home. Oftentimes I'll get a call in the office in which someone will say to me, I want to give my house to my children. I'm now in my later years. I know they won't sell it from underneath me. I know I can stay in that house for as long as I want to, and I'm just going to go ahead and give it away. Now, from a legal standpoint, that is actually the least kind of expensive way to go. It's actually just transferring your deed to someone else or to multiple someone else's, if you have multiple children, let's say, and you transfer it for $1. People probably have heard about that when someone says, can't I just transfer it and give it away to my kids for $1? By the way, as we're going through this, if you have any questions or concerns, raise your hand. I love to have people ask questions about things. So giving away your house, it's the simplest way to go. We just rewrite the deed and we give it to the kids. Now the kids own the house. And here are the downsides of the kids owning the house. You have no protection. Somehow one of the children decides they don't want to have you in the house anymore. They've decided this isn't the place for you to live. Or they just want to sell the house and get the value of the house. They now have all the legal control over the property, and you have none. And so that's a huge downside for you, not to have maintained for yourself any protections against other people making decisions about your primary home. It's also a permanent change. Unless the kids want to give it back to you and are willing to sign the deed back to you, once you've given it to them, it's permanent. You can't pull it back again without their participation in that. There are also some very big tax ramifications to just giving someone an asset like your home. If you give your house away to someone, you can only give what you have in it. And let me explain that to you. You bought your home for a certain price. And probably over the years, you've put improvements into the home. A new roof, a new boiler, excuse me, water. Pardon. You have done landscaping to the house. Maybe you've put an addition onto the house. These are all improvements. So when we want to know what you have in the house, the value you have in the house, thank you so much. We take the cost that you, or the purchase price that you purchased the property for, and we add all the improvements that you've put on it over the years. And that now becomes your cost basis. So if you sold your house, you would end up having to look at a capital gain. That's the difference between what you sell the house for and that cost basis. What you bought the house for plus what you put into it in improvements. Now, you own the home as your primary property. So you get an exclusion. Each of us gets $250,000 capital gains exclusion, and a couple gets $500,000. And that's a good thing in this area because a lot of our houses have increased in value pretty tremendously over the past 30, 40, 50 years. So if you sold your house, you'd be able to claim that capital gains exclusion and not be subject to capital gains. Now, if you gave your house to your children, remember you can only give them what you have in it, what your tax basis is. That's what you bought the house for, plus what you've put into it in improvements over the years. That becomes their tax basis. They go to sell the house at some point in the future, and they are now subject to capital gains, the difference between what they sold it for and what your basis was in the property. And they don't live at the house usually. So if it's not their primary residence, they will have to pay capital gains tax on that increase in value. Does that make sense?
And what is that tax?
So capital gains tax, is usually somewhere between about 26 and 30%. It is not inexpensive. So capital gains is something we like to avoid. So giving your house away is an easy, simple way of being able to transfer it to your children or to other loved ones. It's not expensive to do because it's the cost of rewriting a deed and filing that deed with the registry. But it is permanent, unless they want to play ball with you and give it back to you in the future. There are tax ramifications for them when they sell it. And there may be tax ramifications for you as well. Now, you are allowed to give away assets during your lifetime. Most people hear about the $15,000 per person per year that the IRS says that you can give away without any tax consequence. In reality, you can actually give away more than that. And right now, you can give away $11.2 million over your lifetime, may we all be able to do that, without having a tax ramification. But you do need to file tax paperwork with the IRS if you give your house away, because most likely it is more than the $15,000 per person per year you're allowed to give. And so you have to tell them about the gift, but there is no tax ramification at that time. And unless your estate is extremely large, there most likely will not be a tax ramification for your estate after you pass away. But you do have to file those documents with the IRS. That gift tax return, it is called. Another thing that we talk about is it's now subject to your children's lives. If they are the ones who you give it to, and one of your children goes through a divorce, your house, which is now their house, is part of their asset pool. And so possibly your soon-to-be ex-son-in-law or ex-daughter-in-law is going to end up with part of the value of your house. If your child gets sued, that house is an asset of theirs. If your child went bankrupt, that house is an asset of theirs. And so these are lots of things to think about to just give your children your home and count on the fact that they're going to do the right thing and let you stay there as long as you want to and not do anything to impede the value of that property. Another thing is this thing called the 60-month look back. So most people have heard of Medicaid or Mass Health. When we are doing planning for people and we are thinking about the possibility of needing nursing home care, we always have to think about this 60-month or 5-year look back. What the state says is that if you're going to apply for assistance from the state, you have to meet certain criteria. You have to meet certain financial criteria and medical criteria in order to have the state pay for your nursing home care, which, by the way, is somewhere between about $13,000 and $16,000 a month right now. Very expensive. So if you were looking to give your home away to protect it so it can't be used for your nursing home costs in the future, you have to always remember the 60-month look back. This type of planning has to be done at least 5 years before you could apply to the state for assistance. So that's why, again, planning can be so important. You can't do this in the 11th hour and transfer your house today and apply for state assistance on Monday, because that will cause you a penalty period. Does that make sense? Wonderful. So that's the giving your home away option. The next option is what we call reserving a life estate. Now, with this option, you still write a new deed to your home, you give your property to whoever you want, your children possibly, but you reserve for yourself this thing called a life estate. And it's actually written in the deed. You're reserving the life estate for yourself. And what that does is it means that you continue to hold a little bit of a string to the property. So you've given it away, but you're still hanging on to this little string. And that string lets you do a lot of powerful things. Number one, it makes sure that you still get to use and enjoy the property. The kids can't move in. They can't say, well, you gave the property to me, so I'm going to go ahead and move in. Nope. You reserve the ability to use and enjoy the property for yourself for the remainder of your life. It also protects it against unwanted sales. So the children can't say, we've changed our mind, Mom and Dad. We want you out of the house. We want to sell the house and take the proceeds for ourselves. you again have the exclusive right of the use and enjoyment of that property, and so they can't sell it without your agreement. Now, you can't sell it without their agreement, so there's always a double-edged sword there, but it does protect your ability to stay and enjoy that property. It also continues to be considered your asset for tax purposes. That string that you held on to is really a tax string. And what the government says, what the IRS says is, you haven't completely given that gift over. And so for tax purposes, you continue to be the tax owner. You pay the property taxes on the property, you continue to pay all the maintenance, the homeowner's insurance, the water bill, all of the things that you pay now for your property, you would continue to be responsible for. And because you are doing that during your life, there's a tax benefit for your children after your passing. So you know how I talked about that step up in basis, that there's a basis that ends up being calculated for your property. That's what you bought the property for plus the improvements. That's your basis. And with the other option of just giving your house away, when the children sold it, they'd be subject to a capital gains. Well, one of the benefits of a life estate is that if you hang on to that house until you pass away, your children get it at that day's value, not at your basis. And so if they turned around and sold the property 6 months, a year later, they'll have little, if any, capital gains to have to be subject to and be taxed on. Does that make sense?
No.
Okay. So, if you just gave the property away and didn't keep the life estate, you would have a basis that you gave your children, and someday, and that is what you bought the house for plus improvements. So let's say you bought your house for $100,000. And you put $50,000 into it over the years in improvements. And today, that house is worth $450,000. That's a $300,000 gain that has been earned on that property when you sell it. Again, you live in the property, it's your primary home. If you're the owner when you sell it, then you get to claim the capital gains exclusion. $250,000 for an individual, $500,000 for a couple. So in most cases, you're not subject to capital gains. But if you just gave the house to your kids, again, we're going to use that example that the basis in the house is $150,000. $100,000 you bought it for and $50,000 in improvements you put in it over the years. And they go and sell it for $450,000. They got a $300,000 capital gains and they have to pay taxes on it because it's not their primary home. So if you transfer the house to the children but reserve that life estate for yourself, during your life you're going to be the tax owner. You're going to pay the taxes. You're going to pay the upkeep and all of the bills, the homeowner's insurance, the water bill, just like you do now. You hang on to that property until you pass away. The children now get the property. That string is now broken. Your passing breaks the string, and the house is now theirs. They go and sell it for $450,000. They got the step up in basis. So when you died, if the house was worth $450,000, and they turned around and sold it for $450,000, they'd have no capital gains. If they sold it for $500,000, so it was worth $450,000 when you passed away, and they sold it for $500,000, they'd only be subject to $50,000 of capital gains and not that additional $300,000 that was earned during your lifetime. Does that make sense? So there's a real positiveness to life estates in the sense that you still get to live and enjoy the property. You are the owner for tax purposes. Nobody can kick you out. Nobody can sell it from underneath you. And as long as you hold on to the property until you pass away as your primary home, you're going to end up giving the kids a step up in basis, and they're going to have a reduced, if any, capital gains exposure. So there's a lot of wins here. But remember, there's always a downside to things too. When there's an upside, there's a down. So let me talk to you about a couple of the downsides. You have to hang on to this property until you pass away. Let's say you came to me and you said, I want to do a life estate. I want to give my kids the property. I'm going to keep the life estate for myself. And we did that today. And 5 years from now, you came back to me and said, don't want to stay in the property anymore. I've decided I want to sell it. I want to move on. Well, we could sell it. Your kids would have to agree to selling it because remember, they are on the deed. Even though they're not the tax owners, they're on the deed. So they have to agree to the sale. You have to agree to the sale. But that wonderful step up in basis that they would get for tax purposes, they will not get it if you sell the property while you're still alive. So let me go back to my explanation of the property you bought for $100,000 and you put $50,000 into it in improvements over the years. So now your tax basis is $150,000 in the property. And you gave the property over to your kids with the life estate. 5 years later, you decide you want to sell the property and the kids say, okay, we agree. We'll go ahead and sell that property with you. But the property is now worth $450,000. That's a $300,000 gain that potentially is going to get taxed. Now there are these fancy life tables that the IRS puts out that tells us, based on your age, what is your ownership interest if you have a life estate? So for instance, if you're 60 and you have a life estate in something, your ownership interest could be somewhere around 70, 80%. It's a huge percentage. It's still yours. As you get older, that percentage gets smaller. So let's say you're now 85. Maybe your percentage now, based on those tables, is down to about 20%. And I'm kind of pulling these numbers out of the air. We have to actually look at the tables to figure it out. So let's say you're 85, and you say, I want out of my house. I want to sell it. You own 20% of the house. The kids own 80% based on those life tables. So when you sell it, you'll get 20% of the proceeds. They're going to get 80% of the proceeds, and they're going to be taxed on their 80% of the proceeds because you didn't hang on to the house until you passed away. Does that make sense? So life estates work if you hang on to them until you pass. But if you sell it while you're still alive, the kids are going to get hit with a tax consequence. You may not, but they will, because they don't live in the house usually as their primary home. So life estates are a great way to go, but you have to hang on to that property until you pass away. Another thing to remember is that if you just give it to the kids, remember you still have a string, but you're giving them part of it, their part is subject to their lives. So if they go bankrupt, if they get sued, if they get divorced, that is still considered an asset of theirs. They may not be able to sell it, they may not be able to get the value right then, but it's going to be considered as an asset and could be part of any calculation of a divorce settlement that a spouse, an ex-daughter-in-law, ex-son-in-law may get. And so you just have to remember that.
Can I ask you a question?
Absolutely.
What happens if your kids move into your house with you? Or one of your children moves in with you?
So if you had multiple children, and let's say you had 3 kids, and you gave it to the 3 children, but one moved in with you, and you kept a life estate, that one child may be able to avoid capital gains issues because this is now their primary residence. So that absolutely can help, but the other 2 will not. And you're not gonna get all the proceeds. You know that wonderful $300,000 gain you thought you were gonna get on your house and you could put it in your pocket and do what you wanted with it? Not yours, not all yours. Some of it will be, but not all. So you have to be very careful. If you're going to do a life estate, you need to think about, am I gonna live in that house until I pass away? Can I live in that house? Well, the first thing I talk to clients about when they come in is, tell me about your house. How is it set up? Is it on multiple floors? Do you have to go downstairs to go to the laundry? Do you have a bathroom on your first floor that has maybe a shower in it? To allow you to age in place. To make it so that as time goes on, if you begin to have difficulty managing stairs, you begin to have difficulty in terms of being able to go down into the basement to do the laundry, are you able to live on that one floor? You also have to think about, as you all know, the upkeep of a house. Mowing the lawn, removing the snow, taking care of the roof, cutting down the trees, all of the things that go with home ownership. When you're thinking about, can I stay in this house? You want to say, what is my setup? What does it look like? How much maintenance do I have to do here? Can I afford to pay people when I need to take care of those things for me? And all of that goes into the decision about whether staying in your house is a good thing or not for you. I mean, ultimately, it's your decision. Ultimately, how you decide to approach it is yours. But you do want to think about that because how we are today, as you all know, changes 10, 15, 20 years out in terms of what we can do and what we can't do, and can we realistically stay in the house. And maybe have support come in, maybe have help come in, but then what does the rest of my assets look like to help me support that and make sure that I can. And the last thing about the life estate is to still always remember that 60-month look back, that 5-year look back. Because you are giving part of this asset away, and it's going to subject to the 60-month look back. And so you have to think about that when you're thinking about planning. It's allergy season everywhere right now. Pardon me. So now I want to talk to you about another combination of things that we use, and this is utilizing that life estate, but instead of just giving the rest of it to the kids, we put it in what's known as an irrevocable trust. So let me give you kind of a quick overview of trusts. As I tell people all the time, there are a million kinds of trusts out there, but there are two main categories of trusts. Revocable, or sometimes people call them revocable, and irrevocable trusts. The difference is this. Revocable trusts, you control. If you set up a revocable trust, you still are the controller of that trust. You can change the terms of that trust anytime you want to, and you are the beneficiary of that trust while you're alive. The reason that people utilize revocable trusts are usually for two main reasons. One, it avoids probate. And probate is the process that we have to go through when someone dies. Whether they have a will or not, we have to go to the probate court. If there's a will, the court has to authenticate that will and has to give authority to somebody to now manage the estate and hopefully do whatever it is you've told them to do in that will, to follow the instructions in the will. But we have to involve a probate court, and that takes time, and that takes money. Most probate actions can be somewhere between about $4,000 and $7,000. And here in Middlesex County, it takes about 12 weeks to get someone appointed. You have to keep an estate open for a year. So there's all kinds of rules and ramifications when you have assets go to probate. And anything that you own yourself when you die has to go to probate. Because we don't know what else to do with it. Unless it has named beneficiaries, we don't know what to do with that asset. If you pass away and you own your house, we don't know what to do with the house after you've passed away. We need probate to tell us how to get it to your beneficiaries. When you have a trust, one of the goals of the trust is to take your assets, like your house, and put it into the trust. Now the trust owns it. Remember, you're the trustee, you're the controller of the trust, you're the beneficiary. So I tell my clients all the time, it's really just giving you a fancy way of owning your assets. Instead of you owning your asset, you as the trustee own your asset. But you can still do anything you want with that asset. You can spend it any way you want. You can put it in the trust, you can take it out of the trust, you can sell it, you can do whatever you want with it. Because you are the controller. So that's what a revocable trust does for you. Is it keeps it so that you're in control, you still manage it, but it avoids probate. But it doesn't help to protect the asset if you needed something like nursing home care in the future and you had assets in a revocable trust. The state says, go spend those first. You're the controller, you're the beneficiary, go spend those assets first and then come see us. So it's not a way of protecting the asset. It's just a way of making sure that it doesn't go through probate. An irrevocable trust is like a steel box. This is a trust that you put together. You decide who's going to be the beneficiaries, but it can't be you. So your kids, let's say, become the beneficiaries of the irrevocable trust. You can decide who's going to be the controller of the trust, the trustee, but it can't be you. So oftentimes it's one of the kids. They get to control the trust. So they're the beneficiaries and they're the controller. And it's a steel box. The whole purpose of this trust is to protect that asset from the outside world. So if you needed something like nursing home care in the future, you're protecting the asset. So what we do is we take your house, we keep a life estate for you, that keeps so that you're able to use and enjoy the property and you still remain the tax owner of the property. But we put the rest of it into the irrevocable trust, which is set up to benefit the children. And the reason we use irrevocable trust is oftentimes when we have more than one child, you know the old adage of too many cooks in the kitchen? If we just give them the property, now we've got multiple people owning that property with you. Even if you reserve the life estate, we've got multiple people owning the rest of it. When we put it into an irrevocable trust, we have just one. That's the irrevocable trust. That's who owns it. Now the kids may be the beneficiaries of that trust, but they can't do anything. They can't, if they get sued, they can't come after that trust because the child doesn't have the control over the trust. They may be a beneficiary, but they don't get to control what happens. You do because you've written it in the trust, what's going to happen with that asset. So you keep the control from that perspective. They don't have it. If they get divorced, these trusts can be written to make sure that the asset can't be reached into and grabbed as part of the divorce. So it helps to protect the asset from the kids' lives too. And then what happens is when you pass away, the whole value of the house goes into the irrevocable trust, and the trust then gets divided however you have instructed the trustee to do. Usually they liquidate the house and give the kids the money.
Which they pay tax on?
No, because you kept the life estate. So you're still the tax owner, you get all those benefits that went with that life estate, but you're making sure that the remainder is controlled in a box. It's not going out to the kids individually from the very beginning. It also can give you a little bit of other flexibility. we can actually write this type of trust to allow you, you know how I said in the other one you couldn't sell the house? Because the kids were gonna get taxed? Well, in this one we can. In this one you could sell the house and say, okay, trust, sell the house and buy this house for me. So the house gets sold in the trust and it gets bought over here. In that case, the house is still owned by the trust. You can still keep a life estate in that new property and still have all the use and enjoyment of it and all the tax benefits.
And how does that work if you are going to different states? Does that matter?
So, from an IRS standpoint, no. From the tax standpoint, no. But when you're talking about planning for something like nursing home care, that does change state by state. There is an overarching rules in terms of planning for nursing home care, planning for long-term care, but each state gets to implement them a little bit differently. And so you do have to be careful when you go to another state that your plan will work in that new state. Right. So having it in an irrevocable trust instead of just out to the kids individually gives you more flexibility. It gives you all the benefits of that life estate, but it gives you a little bit more flexibility with the property itself. But one of the very big things to remember is once you set up an irrevocable trust, it is irrevocable. You cannot change your mind. You cannot say to me 3 years later, I've decided I want the house again and I want to use that value for me. You can't say to me, I want to take a line of credit against the house so that I can put a new roof on it. You can't benefit from the value of that house again. If you decided to sell the house and instead of buying a new property, you decided to move into one of these continuing care communities or an assisted living or go and rent someplace, you couldn't use the value of that house to support your needs. Remember, it's the kids who are the beneficiaries of it, not you. Now, sometimes with families, what we do is set these up. The kids are the beneficiaries. For some reason, you need money. You tell the kids, we're going to sell the house. Kids, you take from the trust because you're allowed to do that, and then gift it back to me. It's great. It works really well as long as the kids want to gift it back to you. Remember, they don't have to. So many times it's a great planning strategy. You know your families better than I. And I always try to remind people it's never your children oftentimes that are the issue. It's that their lives are bigger than just you and them. They have spouses, they have children. The spouses always have something to say about things, whether you want them to or not. So these are a lot of things that we have to think about when we set up these kinds of plans, is to make sure you really understand the downsides as well and can live with those downsides should you not be able to reverse things or get the money out.
And who is in charge of that trust?
Well, the nice thing is you get to decide. Some attorneys will allow you to be, I don't. I think it's too much of a risk. Mass Health or Medicaid here in Massachusetts hates these types of trusts. You can kind of understand why. Because you're taking your major asset and you're putting it in a lockbox, not only away from you, but away from them. They don't get to touch it after you get through that 5-year or 60-month look back. So they hate them. And they hate the fact that we can make it so the kids can get the money and the kids can get it back to you. They argue about that every single time. So I don't like you to be in control of it because I think it gives you, as the trustee, too much discretion. We recommend a third party be in that role. It can be one of the children if you think it's appropriate, or it can be another third party. It's however you feel best about it. So you get to control who's in that position. You just can't be the one who's in that position. And you can't direct that person afterward. They get to make their own independent decisions about how to manage the trust. So it's a great way to go, reserving the life estate, giving you all the tax benefits that go with that, being able to kind of centralize the control of the remaining part of the asset in the irrevocable trust, being able to name who the trustee would be, being able to control how the asset would get distributed after you pass away or when the trust ends, but you can't benefit from it again. So you have to remember that.
What is the range of cost for an irrevocable trust?
So for an irrevocable trust, and it depends oftentimes how much in assets it's going to end up controlling, but you're usually talking somewhere around $3,000 to $4,000 to get through that type of planning. Right. But you're protecting oftentimes 500 plus thousand in terms of value.
What's the difference between these and a living trust?
So the living trust is that revocable trust. That's another name for the revocable trust. That one you keep control over. That one you're the beneficiary of. So that one's fantastic for avoiding the probate situation, but it doesn't provide the protection. If you needed something like nursing home care in the future, anything in that revocable, or what we also call a living trust, would have to be spent down first. So you get to keep all the control with the living trust, the revocable trust, and they're the same thing, but you get none of the benefits of protection.
You have to live 5 years though for the irrevocable trust to work, right?
So you don't have to live 5 years. You have to not need state assistance for at least 5 years. So you set up something like this, and none of us has the crystal ball, and God forbid a tragedy occurred, and 2 years after you set this all up, you die. In some ways, that's the easiest of all the situations because you've set up what's going to happen with that after you've passed away. All the benefits will be there. You didn't need state assistance, I'm presuming in this scenario, and so it doesn't matter. Where we get to have a problem is we set this up and a catastrophe happens and you don't die. You become so ill that you can't return home and need nursing home care. Now we have a problem because this has occurred within that 60-month or 5-year look-back period. So the state says, sorry, Charlie, don't come looking to us for help. You gave away your big asset that you could have used to take care of yourself. And you did that within the 5 years. So we're not going to help you. We're going to deny you assistance because you did it within that 60-month period of time. Now, if that catastrophe happened 61 months later, it would be a different story. Because now we could apply for assistance, you're outside of the 5-year look back.
And can that change?
It can. So back in, and I think it was 2008, we went from a 3-year look back. It always had been 5 years for trusts, but it was 3 years for gifts. So you give your children money. You give each of the kids $50,000. That causes a look back. Some people think, by the way, that, well, the government says you can give $15,000 per person per year. Medicaid says you can give 0. So the IRS rules and Medicaid rules are different. So that changed from 3 years to 5 years on everything. And some people have been talking about the fact that the government may look to change that to a 7-year look back or even a 10-year look back. When Governor Baker first came in, he tried to get it to a 7-year look back, and it didn't pass.
And if you have a 5-year in place, does that stay 5 years, or does that automatically change to the 7 if the government changes it?
That's kind of the $6 million question. We don't know. In the past, they've grandfathered in. So they said, before this date, if you had made a transfer, it's subject to the 3 years back then. Anything after that date is subject to the 5. And so if they make a change, we hope that they'll grandfather in all of the planning that currently exists, but they have the option not to if they choose not to. So we don't know. But right now we know it's 5. There's nothing currently in the legislature trying to change that. Although I'm sure you all know, it's Medicaid in Massachusetts, as in most states, is a majority of our budget. And it is a real buster of the budget. And so the state is always looking for ways to reduce the amount of expenditure on Medicaid. And one of the ways is to try to reduce the eligibility. And making it so you had a longer period of time would be one way to do that. So that's the reserving with the life estate.
So they don't go back to the people who you gave money to try to collect, they just say you can't get
Right.
the system.
They can't go back to your kids and say, hey, pony that back up again. They can't. But what they will say is we're just gonna deny mom care, or deny paying for her care. And now the kids have to sit there and try to figure out how they're gonna deal with this. So they can't go back at the kids, they can't force them to give it back, they'll just deny you care. So then there's the do-nothing approach. And it is an absolute viable approach for people. Because the do-nothing approach is really the way to ensure the most enjoyment and use and freedom of what to do with your property. You are the owner. You want to get a mortgage on your property, you can get a mortgage. You want to get a reverse mortgage on your property. You want to be able to use the value of your house to allow you to stay in your house. You have the freedom to do that. When we talk about mass health, if you needed nursing home care and you owned a primary home, it's not true that the state makes you sell it. They can't. They can't make you sell your primary home. You can have a primary home and still become eligible for assistance. So you'll be in the nursing home getting help. You can still own a primary home, but what the state will do is they'll lien your home. So they'll say to you, we'll go ahead and help pay for your care, but we're going to place a lien against your property, so when that property does someday sell or transfers, we're going to get our money back again. So they'll let you keep a primary home, but they're going to lien it. And there's all kinds of other logistical questions that come up. How do you pay for that home? How do you pay the property taxes? If you are not living there, if you're living in a nursing home, because your income does go to the nursing home, you do have to pay that over each month. And so there isn't any money to keep your primary home going. Oftentimes families, when we're in this situation, will choose to rent that home, which the state does allow you to do. They'll let you rent your primary home so that you're making enough money to keep it. You make enough rental money to cover the fair market value of the rental, to make sure that it's covering your property taxes and your homeowner's insurance and your water bill and all the things that you pay now. You can do that. But the state will still lien the property. And they do have a cap on how much you're allowed to have an equity value in the house. It's now $858,000. So it is a fairly, a large equity value that you can have in your house. But if you do have $1 million home and you do have equity for that full $1 million, it will not be exempt for mass health purposes. In that case, they're going to tell you sell it first and then come see us. So the other thing that comes is that tax savings. If you hang on to your house and you do nothing, you don't give it to the kids now, you don't change the ownership in any way, and when you pass away, you leave the house to your children, they'll get that same tax benefit of that step up in its value. They'll get it at the date of death value, which helps to minimize the amount of capital gains exposure they would have. And you know, there can be good reasons to do nothing. Sometimes, you know, when we talk with people about what are your goals, and this is really going back to the beginning when we're talking about overall planning, you need to think about these things. What's important to you? What are your goals for yourself? How do you see things going forward if you could have control over it? Is staying in your home important to you, and you want to make sure you keep the control over the value of that home in case you need to use it? In case you want to take a credit line against it or a reverse mortgage against it, or you want to sell it and be able to use its value for whatever your desires are going forward. Doing nothing and keeping full control over the property may be the best option for you. So again, things to consider when you're thinking about planning and thinking about protecting, or whether you want to protect the value of your primary home. You have to think about control, because remember, the first three things I talked about, you lose some control, if not all control. And it's only the do-nothing approach in which you keep full control. So you have to think about how important that is to you, to have control over the asset, to have control over its value, and to have access to its value. Do you need that value for your own care and for your own needs and goals? Talked a few minutes about reverse mortgages. Reverse mortgages, they do get a bum rap. They were really an issue several years, or I'd say about a decade so ago. The government did step in and put in regulation around reverse mortgages, and I have seen them be a valuable tool for some people. But they have, as with everything else, they have major downsides. They're very expensive. So usually you can loan up to about 60 to 65% of the value of your home. You still own your home. You're not giving it to some bank or to some reverse mortgage company. They're putting a mortgage against it, just like a traditional mortgage. They now have a mortgage interest in the property. You can get the reverse mortgage value in a couple different ways. A lump sum. They just give you the 60 to 65% out, and then you do what you want with that money. Or you draw on a credit line, and you use that money as you need to. And the value of the mortgage increases only as you draw on the credit line. But you have to live in the property. So the moment that you either pass away or that you leave the property for any reason, and I'm not talking about vacation or something like that, I'm talking about leaving it permanently, the reverse mortgage becomes due. So that's something to think about. Oftentimes, you're using so much of the value that you have to understand there may be little if no value left for heirs. So you're choosing to use the value of that asset for yourself. There's nothing wrong with that, but you do have to understand the implication that there may be little if no value left for your heirs. And, you know, again, reverse mortgages are expensive. They tend to take all of the cost of putting the reverse mortgage together, plus the accumulating interest, and it gets tacked on to the value of that mortgage. And that's why you only get about 60 to 65% of it, because the rest of the value is what they're counting on and to cover their cost and the cost of the interest as time goes on. So that's how reverse mortgages work. And then when you're thinking about all of this too, you have to think about the tax ramifications. The tax ramifications for you. Remember I talked about having to file a gift tax return if you do a gifting of your property. And the tax ramifications for whoever you're giving it to. If you give it outright to them and they don't live in the property, they're going to have a capital gains exposure. If you utilize the life estate, whether it's just a simple life estate or the life estate into the irrevocable trust, you can help to minimize that tax exposure. And if you do nothing, and you just pass the property on to your heirs upon your passing, they'll get a tax benefit there too with the step-up in basis. So planning has to be kind of all-encompassing, taking into account what your desires are and what your wishes are for your own self and goals, and then how it affects the people that you're leaving assets to. A couple of other things that I gave you in your packets, and these things I'm really just giving you more for information, is in Stowe. You all have some property tax relief programs that you all should know about, so that to see whether this is something that would be of benefit to you. And there are several different programs that are outlined in here. This here, I believe, was for this past fiscal year. I think that it hasn't, I was told at the assessor's office that the new fiscal year hasn't been set yet, so these might be updated. And I believe you all had a recent amendment that was passed that has increased your asset and income allowances for some of these programs. So definitely, if you're interested in one of the programs, talk to the town hall and make sure that you have the most current information, because you may not qualify based on this, but under the new program, you may. So these are some really great programs that the town has. One of them I had just pulled off for you too is the Senior Citizens Property Tax work-off program, and this is where you're able to do some work for the town and to work off aspects of your property tax liability. And so the town has some nice, the state and town has some nice programs to think about. But I also gave you an article that I wanted you all to take a look at. It's a very recent Boston Globe article that talked about an inheritance damaged by delayed property taxes. So this was a case in which this son had taken over, I believe it was his mother's affairs back in like 2008. He knew that she had been on a deferral program for her property taxes in her town up to that point. And he began to pay the taxes as required from 2008 till now. I believe his mom just passed away, and he's now taken on the property, and he's been hit with this whopping tax bill. What he didn't realize is that while she was on deferral and she hadn't been paying taxes, even though for the last 10 years he has been, that old amount was running with an interest rate. And he got hit with, I think it's about a $70,000 tax bill. And so one thing to know that utilizing these programs, and not all these programs are deferral programs, there are other types of programs too, but a deferral program is where you are not paying taxes or you're paying very minimal taxes and the rest of it is accruing, with the idea that you pay it off when the house sells. That has ramifications to it, and you want to make sure you just really understand what the programs are, and you want to make sure that your ultimate beneficiaries know that you were on this type of program so that they're prepared for what the consequences may be. So it's just an interesting kind of twist to someone taking advantage of a program that was out there and available to them, but not really understanding potentially all the ramifications of it. Are there any questions? Oh, before we start, I do want to just talk about the Homestead Act. So, Homestead Act, if you haven't homesteaded your property, and it's actually a fairly easy thing to see. You certainly can call my office, we can look it up for you, or you can go online now and you can actually look at the Registry of Deeds and you can find your deed. And you can find any mortgage you've ever had and every discharge you've ever had and any change of ownership on your property, etc. And you can see whether a homestead has been filed. Now a homestead, here in Massachusetts, how we describe a homestead is that we believe your primary home has special significance. It is where you live. It is where you raise your family. If you are sued, if someone gets a judgment against you for some reason and they were going to come after you to satisfy that judgment, they now want to get cash from you. The Homestead Act says that your primary home is so important, and we don't want anybody just being able to get it for any reason, that we protect it from people being able to foreclose on your home for the purposes of getting money to satisfy that judgment. And so automatically, everyone has $125,000 in protection on their primary home. That was great when all of our homes were worth $90,000. So now you can also file an additional homestead, and it's a very small cost. It's about $40 to file a homestead, and you get additional protections, up to about $500,000. And if you're considered or defined as elderly, which I believe is over 62 here in Massachusetts, you can actually get an additional amount of protection. So a homestead is absolutely a great thing to have to protect the value of your home from being grabbed by outsiders. Now, a couple of things that never get protected, even by a homestead. If you have a mortgage on your property, they get to foreclose because you're using the property to leverage that mortgage. So it doesn't protect against your mortgage holder. If you don't pay your taxes, if you don't pay your state, federal property taxes, blah, 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 they can always take your home too. So the homestead doesn't protect against that. And the homestead doesn't protect against mass health or nursing home planning. So you can't use the homestead to protect your property from the state putting a lien against it. But it's absolutely low-cost way of protecting your primary property from other situations. So, talked a little bit about this. Remember, planning is never just one thing. It's a lot of different things. You want to make sure that you really understand the pros and the cons of how you want to move forward, and that you've thought a lot about what your own goals are, what your own needs are and desires before you put a plan in place. And that's it. Is there any additional questions that anybody has about anything?
The only way to avoid probate is to have a trust.
No. Another way to avoid probate is to have named beneficiaries. So, when we talk about probate, we're only talking about assets that you own in your own name. A bank account, an investment account, your property. Things like your 401ks, retirement plans, they should all have named beneficiaries. And if you don't, make sure you look at those and get named beneficiaries in place. Those don't pass through probate. They're going to go right to the beneficiary. Life insurance policies should have named beneficiaries. They're going to go to the beneficiaries, never go to probate. So it's only those assets that you own individually. So another way of avoiding is that you could do joint ownership on things. So you could put a child's name on a bank account. But nothing comes without downsides. Once you put a child's name on a bank account, that child could have full access to that bank account and could clean it out if they decided to. So you have to be careful about that. But you might want to do a payable on death or transfer on death beneficiary if your bank allows it. That would allow you then to have that account automatically passed to someone after you've passed away. So there can be, it's a payable on death, it's POD, or transfer on death, TOD designation. Now some banks won't allow that for simple checking accounts and savings accounts. Others will. You have to talk to your bank about that. Some won't allow it to go to multiple people. Some will only allow it to go to one. So you'll have to be careful about that too. If you have multiple children, you don't necessarily want just one of them getting the account, even though we believe in our hearts that child will make sure that their other siblings are taken care of. Because that's where I see the fights, is when the sibling decides not to take care of their other brothers and sisters. So it can happen.
Okay, I live in a low-income home. I own it.
Mm-hmm.
Now that has to go back to the state.
There are restrictions on
Right.
that.
Now, is it beneficial for somebody like me to have either one of those trusts?
So the revocable trust, It has to go back to the state, but it doesn't usually automatically go back to the state. It oftentimes has to be offered back to the state on the sale. And we have to read the contract. There's different programs that they have the first right of refusal. That's one way the program works. Other programs put a cap on how much you can get from the sale. So even if the properties around you had increased, by 20 or 30%, yours may have a cap much lower. So it depends. If there still may be a benefit to a revocable trust because it allows it at least to avoid probate. Because remember, after you pass away, we don't know what to do with that property. We don't know who you want it to go to. That's where a will comes into play, but we have to take that will to the probate court and get it authenticated and get the person named as, we now call it a personal representative, but a lot of people know it as an executor, to manage the estate. So it requires that probate. Where a trust, a revocable trust, would avoid that. Not sure if it can go into an irrevocable trust. It depends on the program, whether they'd let you put it into that lockbox.
I have a will, I have a beneficiary, but I didn't think that I could pass that on to anyone unless they were low income.
So but you bought the property, right?
Yes.
So you put money in it, there's value that belongs to you. That will go to your heirs. There will be caps on it, but someone will buy it. There may be criteria that they have to be low income as well to buy it, but someone will be able to take ownership of that and be able to give the value to your beneficiaries. But we've got to know who your beneficiaries are. That's where probate will come into play, or a trust would come into play.
With trusts, if it's set up for a husband and wife, if the husband dies first, everything goes to the wife, is that the way it goes?
Usually. So trust gives us lots of flexibility that we don't have to do it that way, but typically, yes. Now there are, and this is a little bit beyond today's presentation, there is another benefit to revocable or living trusts, and that's a tax benefit when we have a husband and wife. Massachusetts has an estate tax or a death tax that's set at $1 million. If your estate, and when we're talking about the value of your estate, we're talking about property that you own, your bank accounts, your retirement plans, your life insurance policies, your investments, all of your assets added together. If they're more than $1 million, there's a potential your estate will be subject to an estate tax. Now, when there's a husband and wife, when the first of you dies, there is no estate tax. Everything gets to pass to the survivor without an estate tax. Massachusetts, again, is $1 million. The federal is at 11.2 million right now. So trusts can help us to reduce the estate tax when the second dies. Because if we do nothing, all of the estate will be in the second to die's hands. The first of you dies, everything goes to the survivor. Now all the assets are in the survivor's hands, and that's when there's going to be an estate tax issue potentially. Trust can be a way to help that. And so typically what happens is the trust provides for the spouse, makes sure that the survivor of you has benefits, but also helps to structure some tax savings so that when the second of you dies, the estate isn't as large. So that's a little bit of a different type of planning, but trust can do that for you.
There's
But-
another kind of trust too, tax also, isn't there? There's inheritance and estate.
So their estate tax is inheritance tax. So children don't pay on their inheritance. You're always taxed at the upper level. So if my dad passed away and I inherited $100,000 from him, I'm not going to have to claim that $100,000 on my tax return. However, that $100,000 is part of his estate when he passed away, and there may be a tax at that level if his estate was more than $1 million. Does that make sense? Taxes are always on the upper level, not on the receiving end. So if I gave someone $25,000, they don't pay tax on the $25,000. I may have to file a tax return, a gift tax return, because it was more than the $15,000 I was allowed to give, but they're not going to pay tax on the $25,000. Now, once they invest that money and start earning interest and income on it, then they'll be subject to tax, but not on the $25,000 itself. Now, you don't have to make your spouse the trust, the beneficiary. You can make whoever you want. We even have pet trusts now in Massachusetts. You can leave money to your pet. Which, by the way, if you have pets, you should think about them as well, not necessarily providing them like, Leona Helmsley did with a couple $1 million, but you do want to think about them in terms of, God forbid you get sick, what happens to them? Who's going to step in and take care of them? Even for the short term or for a long term. So it's always something that kind of adds to planning, is thinking about what happens to them too.
So are you saying that children aren't paying an inheritance tax, say on your IRAs or whatever, they would only be paying tax on your house?
No, so what I'm saying is, so let's say you left, so you had 2 children, and you had a bank account of $100,000 when you passed away. IRAs are a little different, but let's say you had an IRA of $150,000.
Just any financial asset.
So the money, so let's just say you had a bank account for $100,000. And you had 2 children. When you passed away, $50,000 would go to one, if that's what you decided, and $50,000 would go to the other. They would get that $50,000. They don't pay tax on that $50,000 when they get it. They don't have to write that in as income. That's not income on their tax return. They get that without paying a tax on it. Now, your estate may have to pay a tax on it, but they get the money. Like if you decided to give one of your children $50,000 today, you could write them a check for $50,000. They put that in a bank account. They don't pay tax for getting that $50,000. Once the $50,000 is in their account and they're investing it, they'll pay tax on whatever they earn in interest on it, but they get the $50,000 without tax. You may be subject to tax because you just gave more than you were supposed to that year. So you may have to file a gift tax return. But remember, right now from a federal standpoint, Massachusetts, we don't have a gift tax issue. Federally, you can give up to $11.2 million. That's a lot of money to be able to give out over a lifetime. So, but who knows what's going to happen with that as the future. It can be kind of hard to bring it back down again. I don't know what they're going to do with it, but who knows?
I bought a Homestead Act around 1980.
Mm-hmm.
It's still good.
It's good.
I'm
If you did it and you haven't changed the ownership of your property, it's good.
No, I'm selling the same property.
You are good. You are good to go.
Since '63.
You are very good to go. Yeah.
What is a grantor? Grantor trust or a grantor something?
So a grantor trust is very much like that irrevocable trust I talked about, in which you're retaining the tax control over things. Grantor is sometimes what we call the person who creates a trust. We also can call them a donor, we can call them a settler. There's lots of different things we can call them. But what it means is that you're intending that the value of that property from a tax standpoint stays with you. That's the purpose of a grantor's trust. So you're trying to make it so the kids get a step up in basis, which is great for property. It's great for stock. It's great for anything that might have capital gains if you're trying to pass it on. Because remember, if you just outright give it to them, they're getting it at your cost value, not at what its value is.
And that has to be written in if you...
So there has to be certain language in the trust to make sure that it is considered a grantor's trust, right? That it has that tax language in it. Exactly. Well, thank you all very much. I appreciate the time today. Thank you.